Looks like everyone's ready. This is a matter of SK versus Obstetrics and Gynecology of Iowa City. Parties are ready. Mr. Booher, am I pronouncing it correctly? You may begin.
Thank you, Your Honor. May it please the court, counsel, Troy Booher on behalf of the appellant, the PC. There are numerous grounds in our brief for reversal. I plan to focus on specification 18E and also the package insert. I'm obviously happy to answer questions about any of the grounds. Specification 18E states that Dr. Goodman, quote, failing to administer medication and treat Mrs. Crompart's low blood pressure after the epidural, end quote. There is no evidentiary or legal support for giving this specification. The anesthesiologist order was to the nurses. It says if the blood pressure goes below 90/40, then, quote, the RN is to administer ephedrine 10 milligrams. The plaintiff's experts agreed that if the nurse needed to report to anyone, she needed to report to the anesthesiologist, not to Dr. Goodman, with regard to blood pressure. To forecast the new argument in the response brief, the anesthesiologist was the captain of the ship with regard to blood pressure, not Dr. Goodman. Dr. Goodman had no knowledge that the blood pressure ever went below 90/40. She testified that the nurse never told her that, and there was no record evidence that any nurse or anyone else did in fact tell her that. That explains, I think, the pivot in the response brief to saying that Dr. Goodman was, in essence, the captain of the ship and responsible for the nurses. Of course, that's not what the jury was told in the special verdict form and by the plaintiffs, is that Mercy was responsible and vicariously liable for the conduct of the nurses, not Dr. Goodman. The captain of the ship doctrine, this court has had the opportunity and not taken it to recognize what it described as a minority view of very broad vicarious liability, making a doctor liable for everyone in the room in the Tappy case. The plaintiff's nurse expert, Shin, explained why it was important that the anesthesiologist was the captain of the ship for blood pressure. Quote, the anesthesiologist needs to be aware of that because they might need to turn the pump off. They might need to cut the dose in half. They might need to consider some other method of anesthesia, 3.9 at page 173. And so this was nurse negligence, and this specification never should have been given as to Dr. Goodman. Under Iowa law, you presume the jury based its verdict on specifications that were given and should not have been and had no evidentiary support. And here, there's no evidence that Dr. Goodman should have known, and there is no evidence that Dr. Goodman did know about the low blood pressure. Sorry, Your Honor.
Thank you. Isn't there an allegation by the plaintiffs, though, that Dr. Goodman should have been in the room between 3 and 4? And you can help me if I've got my numbers off.
Up front on that is that all the low blood pressure was between 230 and 3 when she was in the room.
About that. I'm looking at some testimony by Nurse Shin. I think this is in volume 3. And there's some testimony about some low blood pressures, 93/40, 101/39, 81/67. And it sounds like they're talking about between 3 and 4.
If it's between 3 and 4, then it's duplicative of the abandonment instruction for not being in the room. If it's between 230 and 3, which I think that it is, then there needs to be knowledge, but there needs to be knowledge either way. There's no allegation that the reason that the nurse didn't tell Dr. Goodman of any low blood pressure that I'm not aware of between 3 and 4 was different than the reason she wasn't told about low blood pressure between 230 and 3 when she was in the room. So the nurses just didn't tell the anesthesiologist like they were supposed to primarily, and didn't tell Dr. Goodman between 2:30 and 3 when she was there. And so there's no evidence to support the idea that the reason that she wasn't told between 3 and 4 was because she wasn't in the room.
Just to be clear, it's sort of your perspective that blood pressure is something that a delivering doctor should not pay any attention to.
Doctor who has said you're to report to me if the blood pressure goes below this, because it's my job, I'm responsible for this epidural, that under those circumstances, it can be the delivery doctor's responsibility if she's told about the problem. But if she's not told about the problem, it doesn't become her responsibility for a breach of the standard of care. Yes, that is the position, Your Honor.
Question? I mean, can't the jury make a call on a defense that it wasn't my job?
I think that you have to have knowledge. It's a knowledge problem more than a not my job problem. I mean, the knowledge problem has to go to whether she knew the blood pressure ever went below. And the nurse experts from the plaintiffs testified that it's absolutely the nurse's independent duty to gather that information. And they had a breach of the standard of care by failing to tell the anesthesiologist. And so I think under the record in this case, that's not an available option for the jury, the way the evidence came in and the way that the law speaks to it. We also raise 18A, which is failing to call a backup physician. I think the response to this is, well, we have to presume that the backup physician would have complied with the standard of care. I think if we're going to presume that for 18A, we need to presume it for 18E, and that the nurses would have followed the standard of care, and Dr. Goodman gets to rely on that. 18B, abandoning Mrs. Crompart, the response is we're not bringing that cause of action, point taken, but then why are we using that language? Why are we using the morally charged language of abandonment if we're not bringing that cause of action as opposed to just not being in the room? Which takes me to the lack of neutrality and the way that the grammar of these specifications are put together, where they are basically telling the jury that disputed issues are to be assumed. And so let me just give a flavor of how prevalent this is. Number one, it says there's a non-reassuring heart rate pattern. 18A, 18B, 18C, 19C, 19D, 19E, the jury's told this. Fetal distress, 18D, 19G, 19H. High risk, 18A, 18B, 19C, 19D. Dr. Boyle's testimony, 314, from 18 through 28, shows that all of these are disputed.
True, counsel. Let me ask you this, though. Doesn't the instruction put the burden on the plaintiff to prove these things? And indeed, all of those things can be found in the transcript. And so it seems to me that when we look at the sort of prejudice from these instructions, it's almost like the plaintiffs built a higher burden for themselves to have to overcome by saying abandonment and so forth.
I take your point, Your Honor, because the top of the spec instruction absolutely says the plaintiff has to prove paragraph 1, 2, and 3. But let's look at what a lay jury, and this is from the perspective of the jury that this is analyzed. Let's look at how the jurors would read it. Let's just take 18A, not all the others, even though they have the same grammatical form. Failing to call a backup physician, not if, right? Failing to call a backup physician when she had too many patients, including Mrs. Crompart and SK, who were high risk with a non-reassuring heart rate. All you have to do is construct these specifications that make it clear that the jury has to find all of those things, not just failing to call a backup physician under these circumstances as if they're established. And so specifications, it's not that difficult to write so that they are neutral and are making very clear to lay jurors that these instructions are not telling you that these issues are already decided. And it becomes important because in closing, counsel made it very clear to the jury, quote, the things in the jury instructions, which we will get to in the marshalling, those are the areas of negligence that have to be testified to. They're not from me ever. They come from the court. They come from the court. And so these are the court's instructions telling you what you're supposed to be doing here. And I think the court should at least make clear that these specifications need to be worded in a way that you're telegraphing to lay jurors what they have to decide and what's the background of the question that's already assumed and decided. So the specifications are one ground for reversal. Prejudice is presumed. Prejudice is also presumed with regard to the package insert. And for that issue, I'll just point out that plaintiffs never addressed the 403 argument in the brief at all. And it really should be dispositive because there's not any probative value to the insert, particularly under the record in this case, because every single expert says it doesn't go to the standard of care. It doesn't establish the standard of care. And if it doesn't, that's the only issue the jury's deciding with regard to multiple instrument use here. And so
There are cases that indicate package inserts, manufacturer instructions can be relevant in these types of cases. Is that correct?
and they become particularly relevant when they go to the consumer, such as why prescriptions are fit into that category. But
medical device, right? So it didn't go through pre-market approval. This insert is not approved by the FDA. It's just a clearance process. Is that correct?
record that establishes conclusively which class or that it was approved by the FDA, and so you have to assume no. I think that's right, Your Honor. I agree.
That it goes through a PMA.
Just can't say conclusively because I don't have the record to support that.
So let's assume it is relevant. It seems like maybe the parties are talking a little bit past each other. There's a question of relevance and then maybe admissibility and how the document gets in. So let's work from the assumption that it could be relevant. Maybe it was relevant in this case. So then, in your view, how would a plaintiff have that properly admitted? So take the other side of this for me.
This, you wouldn't have it admitted as substantive evidence. If it's something that experts rely on in forming their opinions, then the jury can hear about it through experts, but it can't become substantive evidence that goes back to the jury room. But this really can't establish the standard of care or be something that experts rely on because we don't know its origin, we don't know the purpose for which it's put together, and everybody says that it doesn't establish the standard of care. So a different insert, maybe.
Plaintiff's red brief at pages 46 to 47 argues that it would not be practical to call a manufacturer's rep. What's your position on that? Should somebody from Midovac been called to testify?
Substantive evidence as opposed to something just testified to, yeah, I think that's right, and I'll tell you why. Because their discussion of the market report exception, which is a brand new theory on appeal that wasn't the basis below, this court in Huser case, in explaining when you can admit labels, and there it was just drug labels for ingredients, say that they can be admitted and they must be evidence of a statement other than an opinion. And so what's the operative decision here or the distinction here under this rule, whether it's opinion or whether it's pure fact? How do we know this is opinion? The package insert tells us at Appendix 342, these instructions are intended as guidelines. Practitioners should refer to the current institutional and recognized guidelines that address vacuum-assisted delivery. So even the insert says, these are just guidelines. It's not a list of ingredients like on a drug. And so it shouldn't ever be admitted for substantive. And it also uses the word contradistinction. Well, there's relative and absolute contradistinctions. And this insert tells you this is a relative one, which is consistent with the literature and the testimony, literature relied on in the testimony of defense experts, which says there are circumstances when you can use multiple instruments.
Might have come in for non-hearsay purpose if it had been offered for that, would you say? For a non-hearsay purpose, effect on the hearer if that had been a theory?
Possibly, but it certainly shouldn't be let in wholesale. And then once it is, prejudice is presumed, but here we've got it in spades because we've got opening statement referring to the FDA and this being an FDA document. We've got the first two experts, I believe, who testified in this case, talk about it being an FDA document, one implying that the FDA approved of it, and we've got the exploitation of that in closing. And this you definitely couldn't have done if it had been come in a different way.
Where your time is up, and you have try to tick off in one-liners. That means don't go into great depth about them. But what do you think is the most egregious and prejudicial conduct that was engaged in allegedly by plaintiff's counsel that would have supported the district court granting a new trial and would have been abuse of discretion?
Your Honor? Yes. I would say I urge the court to read the closing arguments. I would say that it is the, okay.
What do you think? Because I want to hear, even from your hip.
It's vouching for the medical records. It's vouching for them by how many cases that have been tried by counsel. It's vouching for their veracity and telling the jury how it should weigh the medical records. And then it's not even talking in closing about the expert testimony of the plaintiffs. And it's only talking about the medical records and saying these medical records undercut all the opinion testimony of the defense experts, which is in violation of instruction number 15 that says it should only be opinions. Nobody called anybody from the university to come and talk about these records, and the records were repeatedly used, vouched for in closing to say you should punish them because this is a frivolous defense. They shouldn't have made you be here for 3 weeks. They shouldn't have been putting on this defense. They've wasted your time. They've wasted my time. And it is time for you to put a stop to it, jury. I would say that that narrative, as this court said in Kenseth, it's you set up a narrative. It's no longer isolated incidents. It's a deliberate narrative presented to the jury that warrants a new trial for the misconduct. Thank you, Your Honor.
Thank you, Chief Justice. May it please the court. I'd like to start really quick just to clear the brush with the certificate of merit issue, the issue that was raised a month ago.
We need to fix you're already out of time. Sorry, I'm kidding. There we go. Let's start over. You get a free couple seconds. Go ahead.
That issue was not raised below, and so it is not preserved. The response was that, well, this is kind of the responses I think were there was one implied suggesting that this certificate of merit issue is subject matter jurisdiction. That's not true. The statute says by motion they have to raise it. So the legislature made clear it's not a subject matter jurisdiction issue. And now we are now on appeal under the Constitution, and this is not a court of chancery, so this court's review is limited jurisdictionally for correction of errors at law. The district court could not err for a motion that was never filed. And this court made that very point last session in Gomez Medina. So I just wanted to clear that away, but there are any questions?
And in case, hypothetically, we were to reverse and order a new trial on another issue, is this an issue that is likely to recur on remand? They argue that it can be brought, the motion can be brought at any time. Is this, should we address that now, for example, by recognizing implied waiver by litigation conduct as we do with arbitration cases? There's no deadline in the arbitration statute yet. When a party litigates without invoking arbitration for an extended period, we say you've waived it. And Texas courts have said you waive a certificate of merit argument when you litigate without pulling the trigger on that defense.
Rule in our favor, or suggest that the district court rule in our favor if you get to remand, which I hope that you will not, then by all means. But I do think that the jurisdictional issue is one in which that argument has to be brought before the district court in the first instance. I mean, we will have other arguments too if that ever comes up, including the fact that there was, by the scheduling order, there was a dispositive motion deadline. Polk County District Court just recently ruled that that deadline, at the very least, is the one that cuts off the time period. So.
Way to look at this statute be to simply say that it's clearly talking about events in the district court as opposed to them raising a motion on appeal. I mean, just strictly by context of the statute, it's talking about petitions and answers and interrogatories and discovery. It seems like it's clearly aimed at events that have to have occurred in the district court.
I mean, I think there are a host of reasons why it's too late now, and that being yet another one of them. I'll deal with the blood pressure specification first. So I think it's important that there are two instructions about blood pressure, and it's important to look at these two together. The first one is that the specification is that Dr. Goodman was negligent in ordering an epidural, which was contraindicated because of the non-reassuring heart pattern. And then the second one was, of course, then she failed to treat it. So you have to look at these together, which is that the expert testimony was, look, when she's having blood pressure, when the baby's already having a lack of oxygen, you do not want to give it epidural because it reduces the mother's blood pressure, which then reduces the blood flow to the baby. But if you're going to do that anyway, then you need to be able to treat it because, and Dr. Koopmans acknowledged that she knew that this could lower the blood pressure. Just to clean up a factual issue about when this occurred, the blood pressure went below what everybody agrees is the threshold at 247, 305, 308, 318, 348. That's at Exhibit 3, which is District Court doc number 397, and at Bates pages MEH L&D 44-45. So you have Dr. Goodman, and the issue is, well, she did not know. That would be the issue in any failure to treat, any failure to diagnose. Well, I didn't know that this was wrong. If you're going to give an epidural when you already know that it's going to lower the blood pressure, then you are the responsible. And there is evidence that says, look, she is the primary caregiver here. She is responsible. So there's an expert that said that. There wasn't a lot of evidence. I mean, obviously, we talked, the court or the experts talked again and again about forceps, about use of all these kinds of things. And so it wasn't like there was extensive evidence, but there was certainly sufficient evidence for the jury to go on and for this to be submitted to the jury. On the backup physician issue, I just want to point the court to Dr. Goodman's own testimony, which is 316 at page 220. She said, if there would have been an emergency, quote, and she said, and I couldn't have gotten to somebody, I quote, I would have called in a partner. That's what we do. I think that takes care of it right away. There was plenty of sufficient evidence that it was below the standard of care to leave this patient because of the emergent situation she was in. And Dr. Goodman acknowledged that backups are there for this very reason. She did not call one. And abandonment, again, abandonment is a separate kind of claim that has nothing to do here. Their argument is that, well, the word abandon is so morally charged that we must reverse, but yet abandonment is a label that this court gives a claim. They don't like it, I get that, but I don't think it's so charged that it was error. On the package insert, I want to start by actually just going to Justice May. You said that was there some non-hearsay purpose. I think maybe we've all kind of missed the forest for the trees here. It's not hearsay. It is a directive. Don't do this. It is not an assertion. Assertion is something that has to be subject to truth or not truth. In State versus Leonard, it's an older case, 1976, but it gives a good example. The witness testified, John wanted to see me. He had something very important to tell me. What did he want to tell you? He told me to stay away from Sharon. The court said that's not hearsay because it's not an assertion.
It's only relevant to the extent that the advice it's giving is the underlying advice that it's giving has value, and it strikes me that you have a huge problem where this is just a package insert for what I'm pretty confident is a 510K medical device. It's not cleared by the FDA. It was not accurately represented at trial as to what the nature of the advice was. And it could clearly have swung this battle of the experts where you have one expert says one thing, one expert says another, and then here's the government coming in and saying, don't do this. That strikes me as a big problem in the case.
Three things, Justice Mansfield. One, I would look to the Idaho Supreme Court's case in State versus Guerrera, which is 497 Pacific 3rd, 1106. There, a cop testifies about, it was a DUI case, about medication in the defendant's car, and it said, don't mix with alcohol. I mean, that is the same kind of issue here, because the blood alcohol level wasn't high enough to get there, so it was somehow a mixture of the two things that did it. But anyway, and the court there goes through this kind of list and goes through the hearsay handbook of what is hearsay, what is not. And the DeVos case, of course, says that even if an argument isn't made, you guys can consider that at any time, because on retrial, we don't want the exact same evidence being heard. Now we just have to say it's for a different kind of reason. So it can be brought up at any time. As far as the...
Is that it's prejudicial and irrelevant. And I want to hear you more on that.
As far as how much prejudice there is, let's say it was erroneous to admit it. I think it's helpful to put it in the frame of context for what this case was. So first there was an injury but cracked forceps. This doesn't have anything to do with that. Before that, you had lack of oxygen, which caused HIE. This doesn't have anything to do with that. And so the testimony is, there was one quote from one of our experts that says this was just an add-on injury. So first we have, like, how prejudicial was this? This was just kind of like the last thing down the chain. But I think the most important piece of context for this is that there was this battle of the experts. Their expert said it should not be used routinely, but everyone agreed that there is a risk of sequentially using forceps and a vacuum. Our expert said never use it. Dr. Goodman was then asked on cross-examination twice, well, so you're saying, kind of adopting her own side standard, you're saying this wasn't routine. Twice, 2 different times, she said, no, I didn't use them sequentially. So neither standard matters here. That's the point, is that I couldn't get them hooked, so I didn't use the forceps.
Isn't it your case, really, that she did, in fact, use the forceps? Wasn't that a specification of negligence, and wasn't there quite a bit of testimony that she not only used the forceps, but that's how her use of the forceps causes the fracture?
So the forceps causes the fracture. We're talking now, I guess, about, maybe I misunderstood your question, about the use of the vacuum, the sequential use. So the vacuum only just made it worse. So this issue isn't even about the forceps. Maybe I misunderstood your question. I'm sorry.
I was thinking about what you said in your briefing about the idea that maybe sequential use doesn't matter because she didn't actually try to use the forceps. Is that what, did I misunderstand that?
Standards of care, ultimately she said none of them matter because she didn't use it, because she didn't lock it. And so to some degree, that's a credibility issue. And actually, in closing argument, their counsel said there's no evidence that there was a yanking or pulling back. You know, Mr. Feiger said that there's no evidence of that. Actually, there is. The father said it was gruesome. She pulled for 45 seconds and then stumbled back. So when we talk about prejudice, we're talking about how much did this issue ultimately mean, because Dr. Goodman set herself up for the fact that actually none of what we're talking about here about sequential use of instruments matters because I didn't sequentially use them. The jury, it seems by the verdict of all the different things, especially the cracked forceps, about how much pressure she put, just did not believe her. And so ultimately, it's hard to see how this package insert caused prejudice.
And I think we all know from conducting and participating in jury trials, they're so fortunate. They just get to say thumbs up, thumbs down, and a dollar amount, whereas a written verdict by a court has to go through all the details. So let's assume that the jury, because I think you made an assumption, let me make one. Let's assume the jury thinks she did use forceps, but not in a bad way. And then whatever other actions occurred before the vacuum, so that it gets down to the point, let's assume the jury only thinks the vacuum is at issue. That's the only thing that they think could perhaps be negligence. Isn't that where the package where there could be definitely prejudice if all that was introduced, if they believe the forceps were used, but not injury, and then they think, then they believe, of course, that the vacuum was used, and all we've got is this insert with no expert testimony from the manufacturer. Isn't that problematic and prejudicial?
You would have to, Your Honor, then assume that they kind of ignored all the evidence about the injuries that happened before.
They didn't ignore it, but they weighed it, and in their opinion, forceps were used, but not in an incorrect way.
I guess what I'm saying is you don't get to their damage number even close if the only thing that she did was aggravate an injury that she did not cause with pulling from the vacuum, because the big injuries heard.
We don't know how they got their number, other than an argument was made at closing how the plaintiff's counsel was requesting them to do the math, but we don't ever know exactly what went into their thought process. But my point is, isn't it very important that that package insert in this case?
I don't think so in the grand scheme of what this case was about. I mean, it was about, I don't know why he offered it. I mean, but I think ultimately, I think it was properly admitted for all the reasons that I talked about, and then not prejudicial. I mean, the big issues in this case were, did she crack his skull and with the forceps? And the jury the evidence was overwhelming of that. And the medical records at the University of Iowa did say that. And those are important because they are neutral. Look, the experts come in and they talk about it, but there wasn't objection to the medical records coming in. The second issue.
That the sequential argument was incredibly a big part of the plaintiff's case. It was the sequential, can't do this, you cannot do this, and then that. Look at the instruction. So I guess I'm just failing to see how that is not an integral part of the case.
To the closing argument, my time is running out. And also, I think this puts it in context of the statements that are alleged to have been misconduct. You have an oral or a closing argument that was over an hour and 45 minutes long. And you did read it, so I mean, and obviously, and the good thing is we can all read it, so we can all have our own perceptions about what it meant. But for all the alleged misconduct happened kind of like in the first 20 minutes or so, because there are timestamps on the transcript you can see. After that, plaintiff's counsel went through for like an hour and 20 minutes of all the evidence in this case. And then at the end of that, Judge McKeever, after the objection, said, look, I think that there was a fair trial here. If they weren't highlighting some of these things for us, I mean, it is hard to remember that some of these things were even used. Because the evidence was overwhelming that she cracked his skull, because the evidence was overwhelming that he has cognitive problems. And that was a strategic choice on their part, to never call anyone to challenge the life plan. It was either 0 or our number. That's all they left the jury with. And the jury saw this boy with their own eyes, and they said he was cognitively normal. Again, you can watch the video too and see there might have been, they had 2 experts to talk about what damages he might have had, kind of to rebut the life care plan. They withdrew one of them 6 months before trial. They listed the other one on the witness list, but never called them. They tried to cross-examine our people on collateral sources, but there was no evidence. In fact, defense counsel said, I believe Kathleen, the mother, forgot to fill out this form. So she injected her belief into it at times. There's no evidence of that.
Evidence was so overwhelming that that type of behavior wouldn't have been necessary. Perhaps the jury would have gotten there anyway. But even the plaintiff's counsel himself somewhat apologized in closing. Yeah, maybe I should have been a little nicer to the other side. There were some acknowledgments by him as well, right?
You're right. His style isn't my style. He's a very effective advocate. Unfortunately, he had a stroke before this brief was filed, so he will no longer be involved in this case. But the evidence was overwhelming, and so with prejudice, do you send it back? I mean, maybe he didn't need to do it, but it did not affect the verdict. And as far as closing argument goes, as far as improper conduct, there is not a probable outcome that it would have come different. It has to be likely that something else would have happened, and I don't believe that that's the case here. I see my time has expired. Thank you.
I have a follow-up question, or a question about the settlement with Mercy. Is it true that the plaintiffs have released Mercy? The plaintiffs could not turn around and sue Mercy again over this case?
Well, I don't think they. So the plaintiffs signed a release that expressly said, we're releasing you for claims that are not brought in this case. We are expressly not releasing you for the claims that are involved in this case. We will, however, not seek any amount over $7 million. I mean, so it's an odd construct, but I think the 2 sides are in charge of what they want that document to mean or not mean.
Mercy, a released party for purposes of Iowa Code Chapter 668.
Agreement in which they were clear, the language is clearly, it has to mean something. It's just contract interpretation. And
the contract provide that the plaintiffs will not seek any more money from Mercy. Okay, and if we conclude as a legal matter that makes Mercy a released party, doesn't that also make Mercy immune from a contribution claim from the PC?
to assume that they're a released party under the statute, then you are correct, Your Honor.
The 50% of fault attribute the jury found on Mercy reduced the plaintiff's recovery for both economic and non-economic damages. Thank you.
Honor. It's a release and satisfaction. It's at Appendix 111. It's not just a release. It was entered by the court. There's a presumption of prejudice when hearsay is admitted. There's a presumption of prejudice when specifications are given that should not be. That presumption cannot be overcome here. Number one, I want to point out, and we put this at the beginning of our reply brief, that the monitoring strips never went above category 1 or 2. The tests right after birth, including blood tests, showed a lack of HIE. There were bruising all over the baby's body that none of their experts could explain if the forceps only made an injury here. And so this was not the overwhelming case that they're making it out to be. But what we do know is from how the package insert was used strategically throughout trial that it absolutely was prejudicial. I've already talked about the 3 references to the FDA by counsel in opening and plaintiff's experts after the judge, by the way, said don't do that anymore. Nurse Taylor is cross-examined for pages with the insert. Dr. Goodman is cross-examined in 2 different occasions for many, many pages with the package insert. And what do we hear at closing? Apparently, plaintiffs think it's very crucial to their case. I'll give you 2 quotes. I think only one of them was in our brief. First, on page 26. And this thing with the warning on it, you'll take it back. You won't have any trouble. I've shown you the warning 100 times. That's true. Don't use this thing in the face of failed forceps. If the forceps can never fracture a skull, or that's negligence, period. But if you've done something and you fractured a skull and you've used these and they failed, the reason they say you don't do this is it will further injure the brain. And sure enough, it's not coincidence. You'll see it. It's in evidence. The package insert, it's on this too. It says every single hemorrhage that SK had is a danger of misusing this, and he got it. So that's the first discussion of the package insert by counsel. The second, quote, the vacuum says don't use this if there's failed forceps delivery. Read it. Go back to the jury room. He has every hemorrhage they warn about. Causation. Do not initiate the vacuum. Those words are pretty clear. You don't have to be a doctor to know what they say. You can be a nurse. I don't even have to be a nurse. All I have to do is read it. That's at page 51. And so certainly plaintiff's counsel didn't think that the package insert was some minor sideshow part of the case. He believed that it was very important to tell the jury about it. And it was part of the overall strategy. If you read that closing, it's the package insert and the records when no one was brought in to testify about them, the medical records. It's the package insert and the records is their case. Instruction 15 says it can't be their case. It has to be the testimony of witnesses that establish the standard of care. Yes, Your Honor.
Motion briefly. It seems to me, as I was sort of going over with your friend on the other side, that this certificate of merit situation is, the statute is about events that happen in the district court, and that we should interpret it in that way, that it should have been a district court filing in the first instance.
Certainly would be fair to say that that's what's most naturally contemplated. I think that's true. I will point out that you don't need inserts for prima facie evidence because the affidavit of merit in Utah or in Iowa is the prima facie evidence of the standard of care. But to answer your question, Your Honor, I think it most naturally fits there. The Court of Appeals in the McHugh case said that implied waiver doesn't apply here. I think that the line that sets up when this court quotes it and says the statute doesn't contemplate prejudice, the line that sets up is, okay, we're going to presume that the legislature is aware of statutes and the rules that we treat as having the status of statutes in Iowa. But common law equitable principles don't apply here because the plain language applies. And I think if you're at a stage of litigation where a motion can be filed, then the statute applies. I'm not telling you that, I have precedent that says that's how you do it. I'm just saying that is an available plain language reading of the statute, and that's why we brought the motion.
Hypothetically, if we do remand for a new trial, would you invoke the certificate of merit argument on remand?
We wouldn't, Your Honor, and then I suppose there would be a battle as to whether we're so many days before trial or after trial for voluntary dismissal. It's a minor. Maybe we would need to start over again with an affidavit, proper affidavit of merit, but yes.
Though, in one of your filings in this motion practice, you argue the PC gained no advantage by going to trial under these circumstances because they, as opposed to a dismissal with prejudice under the certificate. But had the PC, and I know you weren't counsel back then, had they invoked it early in the case, the statute of limitations had not run, and we've got other cases that recognize a right to voluntarily dismiss without prejudice and then refile with a proper certificate. So they don't have that opportunity anymore. The statute's run.
For a certain stage of the litigation, but there comes a point in time when the voluntary dismissal rule by its own terms no longer applies. And from that point forward, there would be no reason and no advantage gained. But I think you're right before then. I take your point.
Said it rejected an argument the Court of Appeals did that just by initiating some written discovery, they didn't waive their right. And they did invoke the certificate fairly early on. And the point of the statute, of course, is to nip in the bud frivolous cases that lack the requisite expert support. Here, the experts have testified under oath at trial. Isn't this a classic case for waiver by litigation conduct?
I would go that far. I think you're right about the scope of McHugh and what we're talking about in terms of what equitable principles should be part of the background here or be applied. Agreed. But I think the court's already rejected that because after an affidavit of merit requirement, what you'll get is designation of experts and you might even have a deposition. And if that doesn't cure the problem with an affidavit of merit, then trial testimony shouldn't either. So I think that particular ship has actually sailed.
Verdict different?
I don't think so, Your Honor. I mean, it could be, certainly. I mean, I think the final judgment and the jury verdict are certainly two aspects of this motion that are not present in any of the case law. And certainly, I think the court could see those as, watershed different events that make this very different, and so the statute does not apply. I could see a court getting there, but I don't see anything in the statute that says that. And if providing expert deposition testimony or an expert report doesn't cure the affidavit of merit, I don't see why testimony at trial would, and I don't see why a jury verdict that doesn't have anything to do with it necessarily would. I think if that's going to apply, it's going to be because of the stage of the litigation that you're in, not because it satisfies the statute in some way. I think that's probably the better way to look at that. If there are no more questions, then we urge the court to reverse and grant a new trial. Thank you.
SK versus Obstetric and Gynecology Associates of Iowa City is hereby submitted, and the court will take its morning recess.
Hear ye, hear ye.